Good morning and welcome to all of you to the 7th International Congress on Constitutional Law and Discrimination and Equality from the Constitutional Center of the Supreme Court of Justice of the nation. Now, this is Table 4, which will be dealing about indirect discrimination. Thank you so much for being here and for following this transmission and for being present with us. Now, first of all, we wish to remind you all, for those of you that do not know the following, that we have simultaneous interpretation between both languages, English and Spanish. Spanish will take place through the official page of the Constitutional Committee of the Supreme Court of Justice on the Facebook page and the YouTube page of the Supreme Court. The transmission in English will be done through the Constitutional Studies Center. We also wish to remind all of you attendees that the chat tools are active in the different transmission platforms for you to ask any questions or concerns that you may have concerning the talk and the presentations. And now we shall begin with table number 4 concerning indirect discrimination. First of all, I wish to welcome and thank very much the 3 speakers that are here with us today, Sophia Moreau, Khaitan, and Madam Siegel, for being part of this table. It'll be an honor to hear you and to hold this conversation concerning indirect discrimination. And now we shall introduce our speakers in the order in which they will be addressing the floor to know who are with us today. First of all, Madam Sophia Moreau, she's professor on law and philosophy, editor of books of the magazine of Toronto, and a board member of philosophy. Her research lines are focused on discrimination and equality, something that you can see in her recent book, Faces of Inequality, A Theory of Wrong and Discrimination. Thank you so much for being present with us, Sophia. And secondly, allow me to introduce Tarunabh Khaitan, at present Chief Researcher on Human Rights from the Oxford University, Professor of Public Law and of the School of Law. He studies constitutional studies and discriminatory law. He is co-author of different books, like, for example, the Discrimination Law and Foundations of Indirect Discrimination Law. And thank you so much for being with us as well. And also, finally, allow me to introduce Madam Siegel, who is member of the American Philosophical Society and of the American Academy of Arts and Sciences and of the American Society of History. Her research lines are focused on matters on law and inequality. She's an author of Productive Rights and Justice's Stories in the Constitution of 2021 and Directions on Sexual Harassment. Thank you so much, Reva, for being with us today. And now I shall give the floor to Madam Sophia Moreau. She will have 5 minutes to share her few words. Thank you for being with us.
Thank you so much, Professor Alfonso, and thank you to all of those who made this Congress possible. I really look forward to everyone's remarks and our discussions with all of you today. I'm going to take a moment to share my screen because I have a PowerPoint to go along with my remarks. So I am going to talk to you today about 3 lessons about indirect discrimination. I come from a country, Canada, which, unlike the United States, does not treat prohibitions on indirect discrimination as suspect. We assume that direct discrimination and indirect discrimination are just different ways of failing to treat a person or group as the equal of others. I will come back to this little cartoon at the end of my remarks here. Direct discrimination explicitly distinguishes between people on the basis of a protected trait, such as race, religion, gender, and so on, in a context where, given the history of a particular society's treatment of people with that trait, such a distinction can subordinate this group to others. Indirect discrimination, on the Canadian understanding, involves policies that are neutral on their face, so don't explicitly single out anyone on the basis of a protected trait, but nevertheless, such policies become problematic when they have a disproportionately disadvantageous impact on one group on the basis of a protected trait, and thereby work to subordinate that group. Now, I have come before you here at the Supreme Court of Mexico twice before, and I've spoken then on those occasions about the theoretical reasons that I have for thinking that it's right to treat both direct discrimination and indirect discrimination as wrongful insofar as they subordinate some people to others. So I don't want to repeat all of that today. Instead, I'm going to share with you what I think of as three very important lessons to bear in mind about indirect discrimination. They're not actually related, these lessons, except that it's crucial to bear all of them in mind when, as judges, you are hearing a case about indirect discrimination, when as legislators, you are trying to design protections against indirect discrimination, when you're litigating a case as a lawyer, or when you're in the position of someone who is a duty bearer, someone who has duties of non-discrimination, such as an employer thinking of what policies or practices to adopt in the workplace. Okay, so lesson number one. Although, on my view, indirect discrimination is morally problematic when it is, for the same reasons as direct discrimination, I think it is a mistake to do what some scholars have suggested and treat indirect discrimination just as direct discrimination on the basis of a different property. Why might you think that indirect discrimination is just direct discrimination on the basis of a different property, one that isn't a prohibited ground? Well, some scholars, like the British philosopher John Gardner, have argued that if we adopt a common sense understanding of direct discrimination as just treating someone who has a certain property differently from others because they have that property, it might seem that this can capture indirect discrimination too. In many cases of indirect discrimination, the discriminator looks for a certain property and treats some people differently if they don't have that property. So to take two examples of Gardner, when a luxury car dealer requires employees to meet a certain height requirement, it treats some people differently from others on the basis of their height. Now, this might amount to indirect sex discrimination because it will likely be the case that far fewer women meet the height requirement than men. But this is, Gardner says, just height discrimination that indirectly affects women. Likewise, when a department store requires all employees to work evening shifts once a week, and this is more difficult for women because they provide most of the childcare for their families in the evenings, then this is a straightforward case, Gardner says, of discrimination on the basis of not being available in the evening. In both cases, he says, what we think of as indirect sex discrimination is more easily understood as ordinary direct discrimination against people with some other property, people of a less height, for instance, or people with less availability for evening work. So although we may not have realized it, he suggests anti-discrimination laws that regulate direct discrimination actually regulate in a derivative and circumscribed way all of these things that we thought of in a much more complex way as indirect discrimination, but that we can really just think of as height discrimination, strength discrimination, lack of evening availability discrimination, and so on. Well, I think this is a misleading and problematic way to think about indirect discrimination, and I think so for two reasons that I want to share with you now. The first is that even in the case of those indirectly discriminatory practices that can be just redescribed as acts of drawing a distinction on the basis of some other property, It's unclear that we will be able to pick out the particular social group that is in fact problematically disadvantaged, or that we'll be able to explain in a rich enough way why the disadvantage they suffer is so troubling if we see it as connected only to the property on the basis of which they are directly discriminated against. It is, of course, not generally problematic to distinguish between people based on their height or based on their lack of availability for evening work. What makes it morally problematic to do this in the case of female employees is precisely that it perpetuates women's inferior status in the workplace and piles further disadvantages upon women who are already disadvantaged by their gender, both at work and at home. In the case of the luxury car dealer, we might add that women are already underrepresented in this profession. They are deemed less suitable for employment as car salespeople for reasons that have nothing to do with their abilities and everything to do with stereotyped views about women. For instance, that they're less good at taking risks, less strong, and less authoritative, which allegedly makes them both less good at selling cars and less good at personifying the powerful cars that they're trying to sell. In the case of women who are less available for evening work, we need to note that women are disproportionately saddled with childcare obligations relative to their male counterparts for many different reasons, and that even if it is their choice not to work in the evenings, this is a choice that is constrained by social and familial pressures that many men simply don't face. In both examples, these truths about the impact of the policy on women because of their gender will be obscured if we treat indirect discrimination just as direct discrimination on the basis of height, or just as direct discrimination on the basis of lack of evening availability. We need to see the impact that such policies have on women because of their sex and because of the pre-existing disadvantages that they face because of their sex, in order to understand how these indirectly discriminatory policies contribute to cycles of disadvantage and discrimination. Now, the concern I've been expressing here is not a purely academic one, for it's not only academics like John Gardner who have adopted this view and who as a result are at risk of failing to see certain cases as cases of problematic sorts of discrimination. A much more naive version of this view has been, of course, endorsed by a variety of courts around the world adjudicating cases of indirect discrimination. And it's almost always used by such courts to deny redress to certain claimants on the grounds that the discrimination they faced wasn't actually discrimination on the basis of a prohibited ground. There are lots of historical examples we can think of here, but there is actually stunningly and disconcertingly an example that occurred just last year in Canada in the case of Fraser and Canada, which I put up on the PowerPoint here. The three claimants in this case were all female Royal Canadian Mounted Police officers. That's the uniform that you can see by the Canadian flag here. They had opted to work part-time as part of the Royal Canadian Mounted Police's job sharing program. And they had opted to do that because they had significant caregiving responsibilities at home. Now, the police permitted full-time officers who took unpaid leave to buy back the relevant pension credits, but it didn't permit part-time officers in the job sharing program to buy back these pension credits. So the four claimants challenged this policy as indirect sex discrimination under Section 15 of Canada's Charter of Rights and Freedoms. They said it violated their equality rights as women. Now, the majority of the court understood their claim and ruled that the policy did amount to unjustifiable indirect sex discrimination. The majority said, look, the overwhelming number of officers who are in the job sharing program and working part-time are women. They chose to enter the program because they were overburdened with childcare responsibilities. And the police's refusal to let these part-time workers buy back their pension credits heaps an additional disadvantage onto this group, women who work part-time, who are already significantly disadvantaged because of their sex. But, and here's the problem, Justice Cote held in her dissenting judgment that this was the wrong way to think about the case. She said this policy is not indirect sex discrimination at all. It's just an innocuous form of direct discrimination on the basis of another property, the property of having caregiving responsibilities. So she said the distinction in the policy exists not because one is a woman, but simply because one has caregiving responsibilities and so needs to work part-time. Then she noted that there's no prohibition in the Canadian Constitution on discriminating on the basis of caregiving responsibilities. They're not a prohibited ground of discrimination. And so she would have dismissed the appeal. Now, I think the theorists like Professor John Gardner don't themselves endorse this kind of reasoning, but if we take this view of indirect discrimination, the risk is that we invite this kind of reasoning on the part of judges, and we leave them unable to look for the often hidden connections between properties like excessive care, being overburdened with childcare responsibilities, and the actual prohibited grounds like sex or gender. A second problem, though, with treating indirect discrimination as though it's just direct discrimination on the basis of some different ground, like your height or lack of availability at certain times of day, or being overburdened with childcare, is that it's not clear that this way of understanding indirect discrimination will actually capture all real cases of it that are morally problematic. Some practices that are indirectly discriminatory don't, I think, employ any criteria at all to distinguish between different groups, so they can't easily just be redescribed as direct discrimination. They simply lavish resources on particular causes that happen to meet the needs of certain groups while leaving other groups completely invisible and their needs unmet. And this is what has happened in Canada with what we call the Indigenous water crisis. Our federal government in Canada has failed to fund water purification on Indigenous reserves. It never sort of had an explicit policy that it wouldn't fund them because it cared more about non-Indigenous people. This is just something it ignored completely. It didn't take care of it. Meanwhile, local governments in cities and towns fund excellent water treatment systems for the predominantly non-Indigenous inhabitants of these areas. So in this situation, the federal government is not itself drawing any distinction between groups on the basis of any property. We can't redescribe this as direct discrimination on the basis of some other ground. In a sense, it's simply an omission, but it's an omission that has a disproportionate effect, a disproportionately disadvantageous effect on a group, Indigenous peoples, marked out by a prohibited ground. And many of us would see it as a deeply subordinating form of indirect discrimination. So I think however we think of indirect discrimination, we want to leave ourselves able to see cases like this as indirect discrimination and as problematic. So for these reasons, I'm not inclined, the way certain scholars are, to say we can helpfully think about indirect discrimination just as direct discrimination on the basis of another property. But I think that it is nevertheless true that both indirect and direct discrimination, when they are morally problematic, are so for some of the same reasons. And these include the fact that indirect discrimination too subordinates some social groups and some individuals to others. Okay, lesson number two. Lesson number two is that when we think about indirect discrimination, in order to help make prohibitions on indirect discrimination more palatable, we need to draw a distinction that's familiar to us from tort law between culpability on the one hand and responsibility on the other. It's quite possible that not all agents of problematic forms of indirect discrimination are culpable, but we can still hold that they are all responsible in the sense that they too can be asked to shoulder the costs of transforming their practices so as to treat everyone as each other's equals. So I want to elaborate a little bit on this and why I think this. So one of the reasons I think why politicians and members of the public are sometimes suspicious of attempts to prohibit indirect discrimination, there are other reasons, by the way, but this is just one of them, is that it can look unfair to blame some particular organization, say a small private company, a landlord renting out a room of a house, for what is really a much broader social problem that is caused only in part by them and caused to a much greater extent by other social institutions and the history of these institutions. So to go back to the example at issue in the case I just talked about, Fraser in Canada, involving women who bear the brunt of childcare responsibilities, the fact that such women bear the brunt of these responsibilities is obviously not itself caused by the RCMP, the police force. It reflects a whole society in which the workplace is arranged in a certain way, in which caregiving in general is devalued, in which those who engage in paid employment of other sorts are given a kind of privileged social status. There are many structures, policies, and stereotypes that work together to create this situation. And given that, it can seem deeply unfair to hold a particular organization responsible for accommodating women or transforming their practices. But I think the appearance of unfairness here is generated by a mistaken assumption that discrimination law has to be in the business of assigning culpability or blame. And we don't actually need to think that. Tort law can provide us with a very good model here. Judges in common law countries repeatedly note when they're adjudicating tort law cases that when they hold the defendant responsible for some action in tort law, and when they require that defendant to pay over damages to the plaintiff, they're not holding the defendant culpable. They're not making a moral judgment about that person or organization. They're simply holding him responsible and saying, you are the one who should pay the cost. Now, I think that just as in tort law, we can make someone pay for the cost of a certain damage to another person or group by holding them responsible, but without making a judgment of moral culpability. So we can do the same thing in discrimination law. And I think we can make much more progress toward accepting prohibitions on indirect discrimination if we treat them simply as judgments that the particular organization in question has to fix that part of a broader social problem that they can fix. They need, for instance, to pay what is necessary in order to accommodate the discriminatee, or they need, in some cases, to pay what is feasible to transform their whole practice so that no one will be put in the position that the discriminatee is now in. Now, you might say this just pushes us back to a different question, though. You might say, well, why can employers, providers of goods and services, landlords, and everyone to whom discrimination law applies, why can all of these people fairly be asked, in the case of indirect discrimination, to shoulder the costs of accommodation or transformation? Why is the problem of discrimination their problem? And here, as I've written in the lower part of the PowerPoint, I think that we need to look not just to the goals of discrimination law, but to the goals of a democratic society. Many democratic theorists have argued that the very purpose of a democratic society is to create a society of equals. This is true both of relational egalitarians, whom you may have read, like Elizabeth Anderson. It stretches back as early as the political philosopher John Rawls, and most recently democratic theorists like Nico Kolodny are developing detailed defenses of democracy as a form of government that aims to create a society of equals. Well, we all have a role to play in building such a society. In a sense, each of us has an obligation to do what we can to help create that society. But, and this is the last point in black here on the PowerPoint, those who hold positions of power and are in control of particularly important opportunities have a kind of heightened obligation. So employers are in control of people's jobs and careers. Landlords are often in control of whether someone has a home or not. Providers of goods and services are not only in control of whether we can purchase some trivial object, but they're in control of the very means by which we craft lives of our own choosing. All of these people whom discrimination law standardly places duties of non-discrimination on are in a position to make a very large difference to other people's social standing. And that's why I think we can say that they need to be prepared to pay the costs of altering or transforming their policies. This is necessary if we're to be able to live together as each other's equals. Okay, so far lessons 1 and 2 were somewhat of a theoretical nature. Lesson number 3 is rather different and is more practical. So I hope that if you weren't so interested in lessons 1 and 2, lesson 3 is something that might grab your attention more. And it is that well-meaning policies prohibiting indirect discrimination are never enough on their own. We must always also ask, whose perspective is privileged in a given institution? Whose voices are silent? And whose burdens are invisible? And it's only if we ask these questions that we will really be able to identify and ferret out indirect discrimination. Now, to bring this point home and make it more specific, I want to share with you a case that really rocked my city, Toronto, in 2018. And it was a case involving our major theater company, the Soulpepper Theater, which nearly collapsed when 4 of the lead female actresses brought lawsuits against the director and the company as a whole, alleging that there was a culture of workplace sexual harassment that had persisted for over 10 years. Now, their claim, which was quite shocking, was that whenever they had been rehearsing scenes with any kind of sexual content or innuendos, the male director would insert himself into the scene and use the scene for his own sexual pleasure. What the director was doing, the kind of culture he was cultivating, didn't present itself as direct sex discrimination because there was no explicit singling out of female actresses. It was just a culture where doing whatever the director told you to do, even if it was embarrassing, was regarded as the kind of ultimate demonstration of your dedication to acting. And of course, that's why the culture persisted for so long. Once these 4 women had the courage to come forward, over 200 actors then signed a petition confirming that on reflection, this was part of the culture of that workplace, and they collectively refused to work with the company until the situation changed. So the lawsuits were eventually settled, the company was overhauled, there were new female directors brought in, and they are trying now to take steps toward a more self-aware culture. But what's so interesting for our purposes is that during that over 10 years in which these female actresses were repeatedly harassed by the director as part of the culture of the company had policies and procedures in place prohibiting sexual harassment and direct and indirect discrimination of all sorts. And with the kind of further irony, at the time the lawsuits were brought, the company itself had just commissioned and received a report by a series of independent workplace policy experts affirming the appropriateness of their standards and processes and saying that they provided a clear process to report harassment in a safe, private, and respectful way. So this naturally raises the question, how, with such policies in place, could this have gone on for so long? And why did no one identify it? And why did no one feel able to report it? And I think part of the answer is that it was so much a part of the culture of that theater, as I think it at least is or has been part of the culture of so many theater companies, that for women, submitting to whatever a male superior asks you to do has just been regarded as part of the job and as necessary to demonstrate your dedication to acting. The director apparently told actors that in these sex scenes, they had to show their conviction, that this was a test of their conviction and their commitment to the profession. And the claimants later testified that although they felt oddly uncomfortable and disconcerted by this, one of them said, quote, "We didn't really talk about it, calling it what it was, harassment, because to be honest, we didn't know that there was anything wrong with it. At the time, we thought this is theater. This is the professional world," end quote. So this kind of theater culture in which women are not explicitly singled out, but simply expected to please male superiors as part of the job, and this is just taken as a given without ever being remarked on, I think is actually very common. And I wonder whether something like it isn't part of workplace culture in very many workplaces. Obviously, it's particularly salient in the context of theater now because we've had such lawsuits and because plays often involve sexual scenes. So it's, in a sense, easier for sexual harassment to masquerade as just another part of the play. But I really think what happened here was on a continuum with what happens often in other workplaces. What does this suggest? Well, it suggests that if the subordination of certain social groups in the workplace is so much a part of the culture that it's not even recognized as harassment or subordination, and nobody believes the subordinated group when they express a kind of vague unease, and they're not even able to pursue it themselves, talking with each other, then obviously even the best policies prohibiting indirect discrimination can't help. So this is why my thought is we need to focus in particular on who is silent in a particular workplace, on who might be bearing an unfair share of the burdens of the culture of that particular institution. So it's not enough to make sure that there is a reporting mechanism to report what everyone can see as harassment or discrimination. There needs to be some kind of neutral policy whom people can talk to in order to work out in dialogue whether there might be a problem in a culture where that might be so deeply a part of the culture that no one sees it. And there must be a way for employees like these women to get together and talk about it without being punished and to be listened and believed. Okay, that ends what I had to share with you today. Thank you very much.
I'll give the floor to Professor Tarun Khaitan. Thank you very much once again for joining us.
Thank you very much. It's a pleasure to be here. And I believe I'm joining you for the second time myself. And I'll start with the same disclaimer as last time, which is that I know absolutely nothing about Mexican laws. So I'm not sure how much of this work in progress paper will be relevant to you, but hopefully it might be. I'm also really glad to be going after Sophia's excellent presentation, because a lot of what I'm going to say draws upon the themes she's already touched upon, so it makes my task of covering the groundwork at least a lot easier. And in fact, I want to refer to her second criticism of John Gardner's arguments about treating indirect discrimination as direct discrimination on other grounds, which is it fails to really capture indirect discrimination that arises from omissions rather than acts. So the story I'm going to tell, or the argument that I'm going to make, is one that is also about law's omission rather than something, and this is all subject to the extreme difficulty of the line dividing acts and omissions, right? If I don't press the brake when a pedestrian jumps in front of my car, have I acted or have I failed to act? So I know that there is a huge conceptual issue there, but without going into that, just in a colloquial sense, what we think of as act and omission, I'll take that for granted. So the argument that I'm going to make in my talk is that discrimination laws, at least in the Anglophone world that I'm familiar with, they themselves discriminate. And they discriminate indirectly based on grounds, on a certain set of grounds that I've, in my previous work, called non-national grounds. And these include sex, sexual orientation, gender identity, disability, pregnancy, age, marital status, and others. I will also argue that this indirect discrimination by discrimination law is almost certainly unjustifiable. That is, there aren't any good reasons for the law to do this type of discrimination. So here is the first premise, or at least the background to the argument, which is that if we think of the three domains of human activity broadly classified, and of course the boundaries are fuzzy and overlapping, but broadly we act in the domains of the state, the market, and the family. Discrimination law, at least in the Anglophone world, has traditionally only regulated discrimination within the state and the market sphere. In the United States, state regulation preceded market regulation. In the United Kingdom, the historical trajectory was the other way around. That is, the market was regulated before the state. But whatever the historical trajectory, jurisdictions tend to deal with, jurisdictions that I'm familiar with and talking about, tend to deal with discrimination that takes place in the domains of the state and the market. Within these domains, discrimination law usually imposes its duties unidirectionally. That is, the state may not discriminate against citizens, but not the other way around. So citizens are free to discriminate against their state. I don't know what that might take the form of, but landlords may not discriminate against tenants, but tenants are free to choose their landlords based on discriminatory grounds. Retailers may not discriminate against consumers, and so on. So it's unidirectional. It travels from the stronger party to the weaker party, and this is also related to Sophia's, I think, second or third argument about why it may be legitimate to impose indirect discrimination duties on actors who may not be culpable but still have responsibility. And I'll come to that point in just a minute as well. Now, while this unidirectionality of discrimination law is controversial and sometimes misguided, it can be generally justified based on the power dynamic that Sophia mentioned. And so the way I've dealt with that idea in my previous work is to recast the traditional understanding of the public-private divide in liberal theory slightly differently. So in a chapter in my 2015 monograph, I'm just posting I'll send the link if that might be of interest to people. I argued that traditional liberal distinction between the public sphere and the private sphere was based on a binary and sharp distinction, and it was spatial in nature, which was that within the private sphere, the law should stay out or at least apply cautiously. Within the public sphere, the law can regulate. And as we know, that has come under a lot of feminist criticism for a long time. So in this chapter, whose link I've just posted, I argued that instead of thinking about the distinction between public and private spheres in this binary fashion, we need to recast that distinction on a spectrum of increasing publicness, where at one end of the spectrum, at the most public end of the spectrum, is the paradigmatic public state performing its most public function, perhaps of making general laws in its parliament. On the other most private end of the spectrum, we could possibly imagine a natural individual lost in deep contemplation alone in her own room, right? But there's a whole range of possibilities in between, which lie on the sliding scale of publicness or privateness. And in this chapter, I'd argue that at least two factors that determine how public or private an actor is. And the first was sort of relational power, which was the more powerful an actor is in a given relationship, the more public they are, because there's a greater public interest in that relationship. And the second, and this is very similar to Sophia's point, which is that the greater the degree of control an actor exercises over valuable opportunities that are essential to lead a good life, to the success of somebody's life, the more legitimately interested the state and the public can be in those actions. Right? So that was the basis on which I defended the unidirectionality of duties imposed by discrimination law. Employers are more public than consumers, retailers are more public, generally speaking, than consumers, and so on. Now, it's that very idea that I'm going to extend to the family domain to think about discrimination laws on discrimination in a moment. But before that, I need to do a second sort of ground clearing self-referential work, because I've presumed a lot of my previous work in building upon this argument. So just very quickly, in the same book that I mentioned the chapter from, I'd argued that discrimination law's primary concern is with power differentials between cognate social groups. Cognate groups are groups that are defined by the same personal characteristics. So if sex is the ground in question, men and women and perhaps people of other genders might be thought of as cognate groups. Or if religion is the characteristic, then Muslims and Christians and Jews and Buddhists and Hindus and atheists and agnostics would be cognate groups. Right? So I argued in that book that when the power differential between two social groups becomes substantial, so it's not trivial, enduring, that it continues over time, that if men were substantially more powerful than women 50 years ago, that continues to be the case, and pervasive. That distinction does not, that advantage gap exists not just in one domain of human life, but in multiple domains. The same gap exists, right? So in employment, women are less powerful than men. In access to healthcare, women might be less. So in multiple, they need not be all domains, but in multiple domains of social life, we see the same power differential reflected, right? So that advantage gap, I argued, was the main moral concern of discrimination law, because that advantage gap affected the ability of members of the less powerful group to live a good and successful life. Okay, so ignoring the family entirely as a site of potential regulation by discrimination law, and you can now anticipate the argument I'm going to make, ignores that these very same substantial, abiding, and pervasive power differentials exist within the domain of the family as well. and combine this with my previous argument about thinking of the public-private divide not as a binary distinction, but as a spectral distinction, you can also see that I believe that it is legitimate for the liberal state to intervene in the spatially private home or family when the power relations between individuals within that space are legitimately a matter of public concern, right? So combining the two arguments, you will have the proposition that a liberal state can, within liberal limits, and should intervene even within the domain of family and not just the state and market when the primary reason for regulating discrimination, which is these advantage gaps between social groups, exist. This is not new. Paradigmatic examples of such state intervention include regulation of domestic violence and marital rape by criminal law, right? So I'm not making an earth-shatteringly new argument, at least a priori, right? I know that there's a lot of other work I need to do, which I'm going to do in this argument. Okay, so now what is the problem with discrimination law? Because discrimination law regulates all sorts of acts. It also permits a lot of discriminatory acts. Some of those acts are permitted by legislative exceptions. So a lot of clearly discriminatory acts are permitted by exceptions for religious bodies, for example, right? Where the law is trying to find a balance between religious freedom and anti-discrimination norms. Right? And we may agree or disagree about the boundary or the line it draws, but we can agree that there are two interests in tension there, at least in some cases, right? So sometimes there are legislatively carved exceptions. Sometimes the law applies generally, but allows the judiciary to carve out case-by-case exceptions by doing its proportionality analysis. While the law generally applies and says don't discriminate, in the relevant case, judges are permitted in different jurisdictions and different types of discrimination to say, well, here the damage done by legal regulation will outweigh the gain made by, and I'm simplifying, of course, but one way of thinking about it is the gain made by applying the regulation. When it comes to the domain of family, discrimination law omits or fails to regulate. And in borrowing on Sophia's earlier argument about omission, I think we should read the law's silence to regulate the family as an irrefutable legal presumption. Irrefutable because there is no way for a claimant to show that in this case it would be proportionate to regulate this kind of discrimination within the family. So it's an irrefutable presumption by the law that all discriminatory acts within the family are too private, in my spectral sense, to be legitimate objects of regulation. Right? It is this irrefutable exclusion from the intimate domain of the regulatory days of discrimination law that I'm about to argue is discriminatory. Why? So there's certain types of acts within the family domain, and by family I'm including sort of all ways of relating to individuals that are not commercially motivated. Right? So I'm including things like friendships. Right? So if I'm the sort of person who just has decided that I'm not going to make friends with people of a certain religion or people who are disabled, I'm clearly a terrible person, but it's probably not wise for the law to forcibly diversify my friendship circle, because that militates against the very voluntary nature of friendship. Something will be destroyed about the idea of friendship if the law tells me, oh, you must have, 2 black friends and 3 white friends and whatever, right? However, my focus today is on what Arundhati Roy famously characterized as the love laws. I'm sorry about the confusion that the use of laws here will cause, but these are laws in the sense of social rules, right? Mostly social rules. And Arundhati Roy in The God of Small Things describes the societal love laws as, and I quote, laws that lay down who should be loved and how much. So these are basically segregationary social rules that are typically organized around the grounds that discrimination law seeks to protect. Grounds such as sex, sexual orientation, gender identity, race, religion, caste, marital status, disability, ethnicity, nationality, etc., and so on, right? On each of these grounds, the societal love laws identify ideal, tolerable, and forbidden friends, lovers, neighbors, roommates, schoolmates, companions, spouses, and so on. So caste-based endogamy norms in India, which require you to only be able to marry, these are social norms within your own caste, are the paradigmatic example, but the love laws operate across all protected grounds and in different forms in all societies, albeit with greater or lesser intensities in different sections of society. Their main goal is to ensure social segregation manifested in myriad forms, and they police or punish those who try to defy them. Most importantly, for my purposes, these love laws are primarily enforced by the family against its own members. Families, although sometimes even clans, tribes, and communities, organize to segregate those who dare to seek relationships across the boundaries forbidden by the love laws, right? So it could include parents threatening to break off relationships with their parents, or to disinherit them, or more stronger forms of coercion, for example, if they marry against their wishes or marry in breach of these love laws, right? These love laws don't only operate in what are called traditional societies, but also in post-industrial societies. In some jurisdictions, like the UK, have even enacted criminal legislation to deal with the most egregious enforcement of these love laws. For example, the British Forced Marriage Act of 2007 is an example. But these love laws don't operate always at the level that justifies criminal sanction, and nor is criminal law necessarily the best tool to intervene in complex familial dynamics. At best, it's a tool of last resort, but much damage is done if the state waits until things get so bad that criminal law becomes justified. So an earlier calibrated and moderated intervention through civil liability-based anti-discrimination approach, using both preventive and corrective tools, might actually make a lot more sense. So now, of course, the direct discriminators, the enforcers of these love laws, are clearly the family members who enforce these love laws. And they do so across the range of the grounds protected by discrimination law. But the state, in failing to regulate the behavior of family members, is actually indirectly discriminating on the basis of what I've characterized around pages 173 to 176 of my book as non-national grounds. So the distinction between non-national grounds and potentially national grounds is this. Certain types of grounds on which discrimination is prohibited are potentially national in that they have the potential to organize themselves as nation states. Right? This is based on assumptions about what nations are, Benedict Anderson's idea of imagined community, and nations are sort of, aspiring always to become states. Potentially national grounds are grounds of religion, language, race, caste, etc. Non-national grounds are grounds whose groups tend not to seek nationhood or statehood exclusively. Right? These are grounds like sex, sexual orientation, gender identity, age, pregnancy, disability. What is important about the distinction between national and potentially national and non-national grounds is that families tend to belong to the same group as far as potentially national grounds are concerned. Families of course, this is an empirical claim which is different for distinct societies, but family members tend to belong to the same race, they tend to belong to the same caste or the same linguistic group, etc. By the way, because of the operation of the love laws, right? But within families, we do have individuals who belong to different groups defined by non-national grounds. Say, take sex. Within families, we have women and men. We have heterosexuals and LGBTQ people. We have people with disabilities and without disabilities. So children and elderly people against middle-aged people, for example. So the power dynamic between these societal groups is much more likely to be manifested within families based on non-national grounds, because members from vastly different relatively powerful and powerless groups exist within families. I'll wrap up only in a few more minutes now. So I left it at the point where the argument was that the heterosexual, male, cisgendered, middle-aged, able-bodied members of the family enjoy substantial relational power over their cognate group kin within the same family, and they control their access through the enforcement of these love laws to opportunities to enter into meaningful relationships of myriad forms. And this opportunity is a fundamental one that must be available for us to retain the possibility of a free and successful life. So the fundamental requirements for the intervention of discrimination law are clearly in place. Thus, the law's silence with respect to the enforcement of these societal and segregationist love laws in the family domain is itself indirectly discriminatory against vulnerable groups defined by non-national characteristics. Now, it's not the case that I think law's intervention in these scenarios will always be justified. I can imagine certain cases where it may not be. What is problematic is the comprehensive and complete exclusion of family from the regulatory domain of discrimination law that I find problematic. And one of the bills I've been working on is in the context of India on a comprehensive anti-discrimination law, and it defines, borrowing in fact from the American history of segregation somewhat, where segregation by state was problematic, but this is in some ways segregation by society. This anti-discrimination offense, civil offense of segregation, whose definition I've just posted in the chat room. This is something like this within the domain of discrimination law, based on which individuals can get preventive relief like injunctions or corrective relief like financial protection or damages from their families, may well be a limited intervention targeting discriminatory action that denies individuals their basic freedom. And while law does need to tread carefully within the family domain for pragmatic reasons, it has to be sure that it does not make things worse by its intervention rather than better for the victims. Pragmatic issues are not insurmountable, and we have a lot that we have learned from law's regulation of domestic violence, which can be applied in this context. So empowering vulnerable persons to have the option of seeking a legal recourse when being subject to segregation love laws by their own families is, I think, what my American friends, including Reva here, might call a no-brainer. I'll stop there. Thank you.
Okay, thank you very much. Can you hear me now? Sound okay? Okay, so I wanted to thank you for this kind invitation to address the Congress. You've asked me to talk about disparate impact law from the vantage point of a paper that I published a few years ago that explored the enforcement of disparate impact law in the United States over the last decades. It's really actually a half century now. And looked at both court-centered and popular pathways of conflict around disparate impact law. I'm going to start with Tarun's caveats. I don't know the Mexican legal and political context, and so I'm going to have to rely on you for translation. Further, about method, my account is not grounded in an abstract theory of justice or equality. And so I'll defer here to Sophia and to Tarun's observations. What I'm going to try to do is to talk some about how a law that prohibited disparate impact fared in democratic politics in the struggle over disestablishment of racial segregation in the United States. And in the paper, I talk about conflicts over disparate impact liability rules across institutions, both in courts and in representative branches of government, and in different bodies of law, both in the judicially enforceable provisions of the federal Constitution, in particular, the Equal Protection Clause, and also in federal civil rights law, statutes that prohibit discrimination in employment, voting, and housing. And I'm going to speak about much of this in fairly simple terms and hope that the substance of the story communicates itself. I have only a short amount of time, and I hope that the basic contours of this story come through. It is a story in which the United States Constitution, our laws evolved from an understanding of disparate impact law that might be a way of understanding the Constitution's equal protection commands into a present view in which at least many judges see this body of law under the statutes as possibly unconstitutional under the Equal Protection Clause of the United States Constitution, a shift over this time period, as I say, nearly a half century. So as I'm telling you this story, however, I want to observe that disparate impact law is a general theory of discrimination that is applied across many grounds, across grounds of sex, disability, religion, as well as race. And the first branch of my story is really following the story of disparate impact standards in a race discrimination context, not only but primarily. And you could read my story as a story about racial backlash or resistance to race discrimination law. And I close suggesting that this story is not a good predictor of the health of disparate impact standards generally in the United States. While the story might seem to suggest that disparate impact law in the United States is in disrepute or about to disappear or in constitutional peril, if one looked outside the race context, you can actually see that disparate impact standards of discrimination are thriving, maybe even expanding, as I'm going to suggest in my closing remarks. Okay, so I'm going to start in 1970 and with a speech by then President Nixon about the role of federal courts in enforcing, remedying rather, racial segregation in public schools. Nixon called on federal courts to limit the way they defined equal protection violations to cases where there was what he emphasized only a finding of discriminatory intent or discriminatory purpose. At this time in 1970, it was an open constitutional question whether government practices violated equal protection in cases where there was no open or explicit race-based state action. Supreme Court decisions determining when school districts in the South had ended racial segregation often looked to the consequences and effects of state action in determining the constitutionality of the government's or of legislation or government action. And numerous decisions of the lower federal courts in the early 1970s held that the impact of state action would play a central role in determining its constitutionality. In fact, in this period, in the 1970s, there wasn't clear and distinct lines of demarcation between proof of purpose and proof of impact in the way that today in the United States there is. Some courts looked at impact rules as standards on which to determine equal protection violations, and others place a lot of reliance on these standards as evident. Foreseeable impact might be crucial evidence of the government's purpose. This is the context in which the famous case of Griggs versus Duke Power Company was decided, the first decision enforcing the employment discrimination provisions of the '64 Civil Rights Act. And in this decision, the employer, which once had an explicitly racial segregated workforce, and abandoned the open markers of segregation and adopted instead standards that didn't have express racial markers, was held to a finding of liability on the ground that it used testing, high school diploma, and standards of tests that were deemed to be burdensome for the Act's protected classes, particularly racial minorities, who were at that point in time subject to racially segregated schools in the state of North Carolina, a fact which the decision itself takes cognizance of. And this is following Sophia's talk. There's a nexus between the ground of burdening and the history of discrimination against the class. The court in Griggs recognized this nexus, but it said there needed to be no proof of direct discriminatory purpose in order to make a violation under the law there. And after the court's holding in Griggs, a majority of the lower federal courts viewed that as an appropriate way of enforcing the federal Constitution. But in fact, in 1976, the United States Supreme Court rejected that view. Recall that Nixon, President Nixon, had called on the federal courts to restrict equal protection to cases where there was a showing of discriminatory intent. And indeed, he wanted this to be the view of the federal courts, and 4 of the justices he had an opportunity to place on the court voted for a case that drew a sharp demarcation between proof of discriminatory purpose and proof of discriminatory impact. In order to make out a violation of the federal Constitution, it was not sufficient to show impact. You'd have to show purpose. Impact could be evidence of purpose, but standing alone, it was insufficient. And this remains to the day, Washington against Davis, the method of showing a violation of the United States Constitution in cases not only of race discrimination, sex discrimination, other cases and grounds as well. The best understanding of these cases is that the court defined a violation in increasingly narrow terms so as to basically limit the opportunities for showing proof of discrimination. And I'm going to take the shorthand view of this body of law. I think it's fair to say that a proof of a standard of showing discriminatory purpose could be interpreted in ways that are open to discrimination plaintiffs, but the way in which the United States Supreme Court interpreted the standard through the 1970s and into the 1980s defined purpose so narrowly, it was very, very hard for discrimination plaintiffs to make out a showing of liability. I next move to observe that what happened in the aftermath was a differentiation between the Constitution and the statute. In the very same case in which the court drew this distinction between Constitution and statute, it emphasized that the Congress itself was free, this is Washington against Davis, was free to enact civil rights laws that recognized disparate impact standards in various settings that the Congress itself had the democratic warrant, the authority to adopt disparate impact liability standards in whatever settings it deemed appropriate. Quote, in our view, extension of disparate impact rule beyond those areas where it's already applicable by reason of statute, such as the area of public employment, should await legislative prescription. By concluding this opinion in this way, the United States Supreme Court is holding that the enforceable Constitution, the judicially enforceable Constitution, doesn't require state actors to adhere to forms of state action that have no disparate impact on the Act's protected class, on the law, on groups that are subject to discrimination, and we qualified that, but that the Constitution permitted legislators to impose disparate impact liability through civil rights legislation. And the court's actually inviting representative government to extend civil rights remedies in these ways. The court is basically authorizing disparate impact liability rules in this way. And what happens in the aftermath of this development is that there are fights over the extension of disparate impact liability in a variety of settings. There's a tug of war basically between the United States Congress, which is at this point dominated by members of the Democratic Party, and a Supreme Court that is increasingly dominated by conservatives, as there is a difference of view about whether disparate impact rules are an appropriate way of understanding discrimination. Conservatives in this time period attacked disparate impact standards in the voting rights context and in federal employment discrimination law as imposing, and now I'm quoting some of their terms, proportional representation, racial balance and racial quotas, and in conferring racial entitlements. They're taking basically these forms of objection from the affirmative action debates. They oppose disparate impact law both as a form of remedy that's group specific and group conscious, and they think it as a violation of a framework which they believe should be decided on the basis of individual merit and without reference to group membership, or the principle is sometimes referred to as on the basis of color blindness. This debate continues until today. Some conservatives are beginning to express objections to disparate impact law, not merely as a matter of policy, but also as a matter of constitutional law. So what was at once, and at one point in time, a statutory debate, whether it was reasonable, right, and even fair or just to extend disparate impact liability into the area of housing, voting, or into the area of employment discrimination law, where all these debates were had ferociously over the 80s and the 90s, is now beginning to take the shape of constitutional arguments, taking the shape of the argument that disparate impact law itself might violate equal protection. So a body of law that once was understood to be itself coextensive with the Equal Protection Command, a requirement of the Equal Protection Clause, is now beginning to be understood itself as potentially prohibited by the Equal Protection Clause. This is the evolution that's taken place through generations of debate and struggle in the United States. By no means is it the case that all Americans agree about this. To the contrary, there's deep and ferocious debate about it, number one. Nor has the United States Supreme Court so held. But this view is beginning to acquire more and more prominent expression in the United States. I'll further report that as of 2015, when Justice Anthony Kennedy was still sitting on the court, he wrote in Inclusive Communities that the disparate impact cause of action was still the best way of understanding the 1968 Civil Rights Act, which is the basic federal law for prohibiting housing discrimination in the United States, where many people had expected him to repudiate the disparate impact claim, and where the fight over the statute included both statutory and constitutional arguments. Justice Kennedy, in fact, said, no, the best understanding of the statute was that it did include a disparate impact cause of action. This was a statutory ruling, not a constitutional ruling. Nonetheless, given that he was then the swing vote on the court, this was a significant development at the time. His opinion in Inclusive Communities recited, I think, on the basis then of maybe 20, 30 years of fighting over disparate impact law, the understanding that disparate impact framework had proven really essential means of establishing equal employment and equal voting and equal housing opportunity in United States history. He, in his Inclusive Communities opinion, spoke of the ways in which disparate impact liability was a crucial tool for challenging hidden, intentional, unconscious, and structural forms of discrimination. So the opinion in Inclusive Communities in 2015, after many decades of debate over disparate impact framework in the United States, is something of a high watermark, because even and notwithstanding the many generations of fighting over this cause of action, Justice Kennedy recognized not only that the cause of action existed under this important federal civil rights law, but he recognized its long and storied history in ensuring the integration of formerly excluded persons and groups in the United States, recited its many important roles in ferreting out unjust discrimination. Yet, and I do want to observe this, his opinion in Inclusive Communities introduced into the statute certain constitutional limitations on the proof of disparate impact law that never had been seen before. So I'm not going to take this audience into the detail of the opinion, but for the very first time, a majority opinion of the court intimated that certain ways of proving disparate impact under the federal civil rights law might themselves, if too numerically specific and too race conscious, could conceivably violate equal protection law. And this was an opinion that all of the liberal justices on the court signed. There was no way to get to 5, the magical 5 votes in that case without their votes. So as recently as 2015, there is a ruling from the United States Supreme Court that suggests that disparate impact is constitutional, but at the margins might have certain equal protection limits. I observe, and this was unimaginable at the time of Griggs or even Washington against Davis, simply unimaginable. I will also report that the judges that President Trump put on the federal courts are extremely hostile to the disparate impact cause of action. There's one, James Ho, who can be counted on to voice views of the extreme right in the United States, sort of views that perhaps feed ideas to Justice Clarence Thomas. And he, in a recent opinion, rejected a disparate impact claim as an illegitimate kind of argument about race discrimination. He says that, quote, there's a big difference between prohibiting race discrimination and endorsing a disparate impact theory. And he says, quote, it's the difference between securing equality of opportunity regardless of race and guaranteeing equality of outcome based on race. It's the difference between color blindness and critical race theory. Now, I don't know if any of you have been following the fights in the United States over critical race theory, but this is like sending up a big flag from the right, essentially equating disparate impact with quote unquote critical race theory is about as big a flag as you can get in terms of where the right is moving in the United States. He goes on to say that that a presumption, if there's a disparate impact, that would evidence of racial imbalance, treating that as a presumption of discrimination would run into a quote bedrock principle of our legal system. We ordinarily presume innocence, not bigotry. Just people might want to take this in about where the law is going in the United States. Plaintiffs must typically prove, not presume discrimination. We should not automatically presume that any institution with a neutral practice that happens to produce a racial disparity is guilty of discrimination until proved innocent. So this tells you something about, I can see some smiles here. This tells you something about where our law could continue to grow. Okay, so my last chunk of my little talk here, it sounds like disparate impact in the United States is in the death throes here, like about to go off the rails, but I have a little surprise ending for you. So over the decades, Congress has incorporated effect standards and accommodation requirements into a large body of civil rights legislation governing discrimination on the basis of sex, disability, and religion, as well as race. Remember, I said that it was not just limited to race. And I want to report that conservatives are much more willing to accept accommodation requirements as bona fide non-discrimination requirements in contexts that are not specifically about race. Important to observe. So just to take a recent example, Pregnant Worker Fairness Acts requiring reasonable accommodation of pregnant employees have passed in many states by lopsided majorities and may even become federal law. This happens to be a form of law where both feminist and pro-life majorities can, or groups can, come to possible lines of agreement. Both the Americans with Disability, or the ADA, and the Religious Freedom Restoration Act passed with bipartisan support. So this is, again, these are statutes that have various forms of accommodation or disparate impact standards built into them. Many who supported the Religious Freedom Restoration Act back in the 90s invoked concerns about protecting religious minorities and drew on effects and disparate impact standards from the race context when they advocated passage of the act, which was again passed with a coalition of senators on the left, of congresspeople on the left and the right. The Religious Freedom Restoration Act provides, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. So in other words, it's allowing challenges to laws of general application. So today, conservatives seek exemptions from laws of general application to accommodate religious beliefs of Christians and call refusal to provide such accommodations from laws of general application discrimination. This is just a regular form of talk in the United States. In fact, many of these same conservative judges are now pressing to expand the Religious Freedom Restoration Act statutory framework to the constitutional context, where in fact it once originated from. Presently, the Free Exercise Clause, this is our religious freedom clause under the Constitution, is interpreted in ways that are aligned with our equal protection laws. So in order to prove discrimination on the basis of religion, you'd have to show something like purpose or targeting or something. So it's not enough to show disparate impact. But observers expect that the Supreme Court may soon change the proof rules to allow claims of religious discrimination, even in circumstances where the challenge practice is facially neutral and there's no showing of discriminatory purpose. This last term, in a case called Fulton versus City of Philadelphia, the Supreme Court held that a city policy that asked Catholic Social Services Group to place foster or adoptive children with eligible families, including families of same-sex partners, on a non-discriminatory basis, violated free exercise because this anti-discrimination law of general application burdened the Catholic group's religious exercise. So I'm going to spare you the details of the case, but I'm going to close by observing that the same court would not find that a law of general application that disparately burdened racial minorities violated equal protection. And many conservative members of the court would hold that a statute enforcing such a disparate impact standard in the race discrimination context was prohibited by equal protection. So I leave you to ponder the meaning of these disparate developments.
Thank you, Professor Siegel. Now we're going to go to questions. We are really tight with time. So what I'm going to do is I'm going to be presenting the questions that we have received, the main questions that we have. And later on, I'm going to give 5 minutes each the floor, so you can react before these questions. And that way we can finish on time, if you're okay with that. There's so many comments, and thanks for having shared this time with us. And there are comments and from different parts of the country, which means that many people are connected, and also the impact that this is having. And there is at least 4 different types of general questions that have to do with this. The first one is going to be the relationship between direct discrimination and structural discrimination. And is this correct or not, that structural discrimination is at the end motivation and cause of direct discrimination? Maybe some cases are not related. With respect to this, there's different specific questions with respect to the cases that were mentioned. Different cases where they're considered when there are different women, and that we do not repeat the idea where women are responsible for care, and also cases where paternity or maternity leave are different, and then we're leaving out other type of couples. So a little bit, if you can tell us what is the relationship between both the elements, subjective and direct discrimination. The second type of question is with respect to the challenges of indirect discrimination to the courts, whether it is necessary to develop different methodologies in adjudication, and in particular, there's a strong concern for the proof and how working with the burden of proof can be shown, can be worked. And the third type of question is with respect to the results, with respect to the repair of indirect discrimination. And the structural results that are associated to the different social groups is what we should be expecting as of what you mentioned. And last, there is a concern in different questions with respect to indirect discrimination in state regulations. How do you perceive and how do you understand indirect discrimination that can come from regulations of different state agencies that generate asymmetric filters for different groups of population by establishing a specific requirement to take a certain post and to use different positions? And what would be the different ways that you imagine or that you know from your own experience in order to be part of the situations if this is indirect discrimination? So I'm going to give you the floor in the different order as the intervention so we can approach this. And I'm going to go with Sophia and then with Reva.
Okay, thank you so much, all of you, for these terrific comments. Professor Alfonso, am I right that you would like us as a group to talk through each of these 4 sets of issues? Yeah, so I'll maybe start off with a few remarks and then we can have a group discussion about the first set of issues. And then when we feel like we've done a little bit of that, we'll move on to the second and so on.
I think that makes best sense. I mean, in other words, just start and we'll see if we have something to add in. Yeah.
So the first set of issues, as I understand it, concerned the relationship between direct discrimination, or which is sometimes intentional, sometimes motivated by prejudice, and then structural discrimination, and how these two tend to be mutually reinforcing. And then there was a related question, as I understood it, about how when we try and address this web of direct discrimination and also then policies that together constitute structural discrimination, that we need to be sure that we don't thereby cause discrimination on other grounds against other groups. So the example given was when we're thinking about parental leaves and we want to try to adopt policies that protect women, we don't want to leave out single male parents or same-sex couples. So we need to be aware that the policies that we can adopt to try and rectify discrimination on the basis of one ground might then lead to indirect discrimination on the basis of other grounds. So I think that's very insightful. I don't have, I'm hoping that Professor Siegel and Professor Khaitan will maybe have some specific examples, but let me just say that it does seem to me quite right that these forms of discrimination are mutually reinforcing. That very often there are particular forms of direct discrimination that persist in part because there are policies that just help keep it the case in society that certain social groups are marginalized and have their needs ignored, or that it's acceptable to think about them in certain stereotyped ways. And then conversely, when there is overt direct discrimination against certain groups that's viewed as acceptable, obviously there are all sorts of policies that disproportionately disadvantage them that then fly under the radar that are not addressed. Did the two of you have other things they wanted to say on this point?
Sure, if I may add a few things. Reva, did you want to?
No, go right ahead, Tarun.
Thanks, Sophia. So just on, so I have two things to say. The first is on the worry that discrimination law can sometimes reinforce gender roles. I think that is a real worry because on the one hand, the law has to respond to the reality that caregiving work is primarily shouldered in our societies by women, which in turn imposes several disadvantages on women. But the recognition of that social reality by law itself can reinforce that gender role stereotype and therefore concretize it. There's a fantastic South African case called Hugo, where President Mandela pardons all mothers who had children under the age of 14. And obviously there was a sex discrimination case. The court upholds the order because he did not, even though he did not pardon fathers of young children. But I think indirect discrimination law is different in this case because it draws attention to those who are left out by thoughtless or stereotype-based regulation, which would include laws that only give maternity leave to women, but not parental leave to both partners. And I think in some ways, indirect discrimination law forces the law to be more fine-grained and actually allocate the benefits to those who in fact perform caregiving duties, whether they be men or women. And I think, I'm sure there's a complexity here which I'm not seeing, but I think that that's, in my view, better. Indirect discrimination forces us to think about the actual criterion of allocating benefit rather than using proxies of gender, which solves the stereotyping worry. And the second thing I wanted to say, I think I might have misheard, but I think I heard a question about the judicial rule. And that actually connects me to perhaps a tension between Sophia's presentation and Reva's, in that when Sophia draws upon the distinction between responsibility and culpability, and says that it's okay for the law to impose duties on those who are responsible, even if they're not culpable, even if they don't have any blame. And I completely, agree with that statement. But the implication of that moral position is that there is a distributive dimension to indirect discrimination law. That indirect discrimination law is not simply about correcting your past errors or mistakes. Right? Now, if you accept that, so for most jurisdictions, that's not a problem, right? Because they are quite happy to impose distributive burdens on private actors, right? But for the United States, in the story that Reva says, that is a huge no-no, right? And when you were explaining, Reva, how conservative groups are saying, this is the presumption of guilt or whatever, right? So if you only frame as guilt or innocence, then that story reverberates, right? But implicit in that charge is the assumption that the law cannot possibly require private individuals to engage in distributive justice, right? That's socialism. I'm just sort of imagining what the objection might be to hearing Sophia's point. Right? So if the judicial role must be premised on a finding of fault in indirect discrimination liability, then the American conservatives are right in at least their assessment of what the law is doing, right? Which is that it is allocating responsibility without demanding fault. That's okay with me, but if you're committed to the position that the law can't possibly do that, like at least a strand of American constitutional thinking might be, then we do have a problem, don't we?
I don't think so in the following sense. It depends on what in order to draw the distinction between guilt and responsibility, you'd need to decide for what act of wrongdoing. And answering that question depends on the antecedent mental state that is used to define discrimination. So if the employer, in fact, is employing practices that are entrenching or exacerbating racial stratification, even if there's no accompanying intention to do so, that agent nonetheless could be responsible for entrenching or exacerbating racial discrimination without an intention, and so be held fairly responsible for, the results or, remedying that situation. So it all depends on what the underlying wrong is understood to be.
Can I jump in here for 1 minute and then I'll give the floor back to you, Reva? Yeah, I tend to agree with Reva on this. I've done work in which I've argued that the relevant standard of fault here is like the negligence standard in tort law. Reasonable people in a particular society will anticipate or desire to look into the impact of their policies on disadvantaged groups. And so even if there isn't an intentionality, nevertheless, there is negligence in the same sense that's familiar to us from tort law, and we can therefore attribute responsibility in that sense.
What's so crazy in the United States is that we've adopted this purpose requirement, which tends to have the effect of, if you'll excuse my language idiomatically, which may or may not translate, whitewashing all of the forms of state action. That is to say, there's ongoing action on the part of the government that entrenches racial segregation. But insofar as that state action is not explicitly, intentionally race-based, then it doesn't appear that the government itself is acting in ways that are continuing to entrench racial stratification. But once you change what the mental state requirement is, or the liability rule for defining discrimination, then you can say that the United States government is continuing to entrench racial stratification. It's just, consider the United States criminal law, for an example, right? So you could say it's continuing to entrench racial stratification. It's just not doing so by means of forms of state action that expressly discriminate on the basis of race or intentionally discriminate on the basis of race. And here's my last point, as to the credibility of that characterization of US policy, let's just switch grounds of discrimination. The same conservatives who would reject that account of the US in the race case, in the religion case, are energetically using this same structure to characterize religious discrimination. That was the point of my talk. I hope it came across calmly and briefly. It's stunning. It is stunning. Can I say it again? It is stunning. They use the language of discrimination and various forms of burden and impact and all. And it used to be the case that the proof rules for discrimination were traveled together across the free exercise, the religious freedom clause of the First Amendment and the equal protection clause of our 14th Amendment. The standards were traveling together. So there was an impact-like standard in the Warren Court in the 60s and 70s. And then as the court went more conservative, it shifted to something like a purpose requirement. And now it's about to shift back to an impact requirement, but only for the case of religion. That's what I'm reporting to you, just so that my story comes through.
Can I respond to that exchange briefly, Tatiana? Which is that, so Sophia, what I'm going to say on negligence, right? Which is that it captures most, but not all cases of indirect discrimination, because at least in British law, it's a strict liability offense, and no amount of good faith or due diligence saves you. But I think for American progressives, that might be the most stable route to defend most of indirect discrimination or disparate impact liability by casting it like this is a tort-like standard, which could entail negligence, that could entail recklessness, that could be deliberate, sort of Griggs-like, I'm going to hide my intentions by doing something, and so you can allow for a range of men, and not much will be lost in practice, yes, because that small minority of case where there is good faith and due diligence, maybe, if the law does not catch it, that's not much is lost. But I think making that explicit might be the best ground on which you can defend American disparate impact law.
That's very interesting. Shall we move on to the second set of questions, which, as I understand it, had to do with challenges arising during litigation, in particular to do with proof and burdens of proof that are imposed on the claimant? Are there particular challenges that arise in cases of indirect discrimination? So I guess, one place where there are obviously challenges concerns how you prove a disproportionate impact. Do you impose a very onerous requirement on the claimants to provide statistical evidence? Do you allow a sort of looser statement that in general there seems to be a greater impact? Tarun can speak to the UK approach, which I gather has erred in favor of claimants and a looser approach, and so has Canada. Tarun and Reva, did you want to speak either to this point or to other challenges?
Well, we have had, first of all, there has been a fair degree of litigation over the proof rules. You need something like a public body of data about your employment discrimination force and census information. You need statistical information about your population in order to enforce many features of this body of law. And if that information is not there, it's going to be very hard to make out a variety of claims, unless it's extremely impressionistic. That's point number one. Point number two, our Equal Employment Opportunity Commission in the early decade, remember I told a story that's a half century long. So in the early decades of enforcement, when there was serious interest in enforcing the Griggs regime, came up with a way of, excuse me, of validating employment tests. That is to say, methods that the Equal Employment Opportunity Commission considered standardized methods for determining if tests were job related. And it's still used to ascertain whether the employer's use of various measures for determining applicants' fitness for employment are job related within the meaning of this framework. So there are many pathways that could be built out in an administrative state. They need not be, but they could be. And to the extent that one wants a reasonably solid body of law that employers could be held to in some serious way, our disparate impact law, I believe, made the most difference, even though I told you it's a body of law that's enforced under the statute rather than under the Constitution. I believe it made the biggest transformational difference in our public employment in civil service, because the statute in 1972 was amended to apply to government employees. And this body of standards actually played a very significant role in holding police and firefighters and other civil service bureaucrats to these standards and opening up closed workplaces to minority and women applicants. So building out these frameworks of proof, both administratively and developing the legal standards to feed this data into legal contestation, made a very significant difference in making this law make change on the ground.
Just to report on the British and European rules, so the requirement of statistics that Reva alluded to became a huge burden on claimants to win their cases. And often these statistics, especially with private employers, were with the defendant, and you have to use discovery rules, and it's when the weaker party needs data that is with the other party, it's very hard to win litigation, right? So for the change came in European law and then adapted into British law, where while disproportionate impact remained something you could show to win the case, an additional way to show it was in legal language called when it puts the group at particular disadvantage. It's not any clearer than disproportionate impact, but that was clearly interpreted in legislative data, and judicial interpretation have confirmed that what that means is that you don't so statistics are sufficient, but not necessary for proving disproportionate impact, that judges must take judicial notice of well-known facts of societal relative disadvantage, basically what Reva described as presumption of, not guilt in this case, but presumption of disadvantage. And they said that, judges must not demand proof in those cases. The second point on adjudication I should mention is one of the worries about going down the intentionality route, the tort law route, whether it's negligence or recklessness, etc., is that unless the law is very clear that judges must presume that mental state of fault rather than demand proof, it'll become an additional hurdle for claimants to clear. They'll have to show, in addition to disparate impact, also that there was some faulty mental state, whether it's negligence or recklessness or intentionality.
Can I just only simply say one thing that seems helpful to observe? So I told a story about the United States law as really moving in a direction hostile to disparate impact law. That all came about because initially our law was enforced in a way that made significant change on the ground. The pushback didn't happen just out of the blue. It happened because the law was enforced in ways that actually made change on the ground. Mm-hmm. And that didn't happen because some people just had intuitions about, judicial notice of there being a difference. There was actually an enforcement regime that was built out, even, quote, if it was statutory only and in the end not constitutional, it was enforced in a reasonably systematic sort of way with reporting requirements and numbers and proof rules. And the administration of that framework didn't change all workplaces, but did change enough workplaces with enough bite, as they say, that it actually affected who got what jobs. And it's under those conditions that dispute really started to arise about who was entitled to which jobs and what standards should apply. And so I'm just reporting to you that learning about the history of this could be helpful in building out a system. Sorry.
So perhaps in the remaining few minutes that we have left to us, we should just very briefly address any of the third and fourth concerns that you feel you would like to say something about, Tarun and Reva. Results and repair of indirect discrimination, or state regulation of indirect discrimination, and ways in which different state agencies could either be implicated in or respond to indirect discrimination.
I think in the interest of time, I'll just pass.
Okay. Reva?
No, I mean, if we need to wrap up, we can wrap up.
Okay. Well, let me say that it has been a tremendous honor to be on this panel together with Reva and Tarun. And thank you so much, Tatiana, for moderating it. These are, of course, always ongoing conversations. And it's actually, I think, very exciting for all of us, even though Tarun and Reva and I are from countries that, in some sense, have established bodies of anti-discrimination law. They're still very much evolving, and indirect discrimination in particular is a phenomenon that we are all in our different countries still struggling both to understand what it involves and to think about what sorts of protections can possibly effectively prevent it. So these sorts of discussions are just tremendously helpful for all of us.
Thank you so much, all three, for being here with us. This was an extremely interesting and enlightening conversation, very useful, as you can see in the comments. That we want to thank you again for your generosity, for the conversation and the final debate. That was impressive. And also everybody that has been with us during this streaming, thank you for your understanding with the patient, with the translation. Thank you for your comments. And we just want to invite you once again to be with us on our next session, October 28th, Thursday, 9 to 11, with the topic, the proof of discrimination. Thank you so much, and have a great day, everyone.